some other things, but let's talk about this guy now since he's here. So first of all, your Article 3 application, Article 3 grounds on Article 3 medical ground is application to remain in the UK on medical grounds. So what you are telling the Home Office is that you are having a very serious illness,
medical problem,
if you are being taken back to your home country, it will amount to torture or degradation because you won't be able to receive treatment in your home country, or the treatment for that illness is not available in your home country, so that you should be given permission to stay in the UK because you are receiving treatment for that illness. And you have to provide a letter from the NHS consultant stating that, Mr. So and so is our patient, we are seeing him, is on this and that, his treatment is for so and so. Understand? So now, is an application that can work, but in very rare cases. Because now, for you to get this leave, you have to, like I said, that illness would be serious and you won't be able to treat it in Nigeria. So now, I heard he mentioned type 2 diabetes. Type 2 diabetes is serious and sometimes manageable. People live with it for a long time. And there's treatment for it in Nigeria. So Home Office is likely going to refuse that kind of application because you won't be able to prove that, you can't receive that treatment in Nigeria, or there's no medical facility to
take care of that,
in Nigeria. You understand? So that is what Article 3, a medical ground, is. But if you don't meet the right lawyer, they can just put in that, you are written you have 60-day notice, okay, let us do this. And they may not even explain it to you very well. They will just say, my lawyer has put in an application for me and I'm okay. But you don't know the application they are putting. You don't know the requirements, whether you meet it or not. Even if you don't meet the requirements, some lawyer like me, I will still explain. Say, you don't meet this requirement, but okay, we'll still put it in just because you are still allowed to put in an application. You can even apply for British. If they give you 60 days notice, before your 60 days expire, you can apply to be British. It will still go in like an application. But we all know it's not going to work, but it's still an application. But the problem is that people don't understand the kind of application they put for them and what it's all about. Even something like fee waiver. I heard someone talk about fee waiver on that video I watched, the video of yours I watched. So I'm going to talk about that as well. So now, with this application, when it's going to be refused, it's going to come with an immigration bail condition, meaning that you'll be placed on immigration bail and you are subject to detention and subject to removal. So you won't be able to make any valid application in any point-based system visa category. The only application you can make that will have a chance would be under family life. You understand? So that is in putting such application, because it can buy you time, but not for long, maybe 2-3 months. You understand? Then another thing is that the application is free. So you see someone paying lawyers. Someone says, my lawyer charged me 1,000 or 2,000, and they did this for me. Blah, blah. So if in their mind, they think that they have done a very good application for them but the application is free. You don't pay for Article 3 medical ground application. You understand? So I just thought I should make him understand his application, first of all. Now, for your right to work, when you put in an in-time application, so in-time application means application that you are putting before your visa expires or before your leave expires. So if you receive 60 days notice, then your 60 days expiring maybe 1st October. If you put in application 1st October before 12 midnight, then you are putting an in-time application, meaning that your leave will be extended by virtue of Section 3C. Your leave will be extended by virtue of Section 3C of the Immigration Act 1971. So you will still remain legal in the country with your right to work. If you were a student, your right to work will still be 20 hours temp time, full-time holiday. If you are a dependent, your visa condition will still remain full-time other than sports person. If you are a skilled worker, your skilled worker visa condition is full-time with your sponsor, 20 hours supplementary employment with any other sponsor. You understand? So as long as your application is still pending a decision, all your visa condition remain the same, and you still have your right to work, and everything remain the same until there's a decision on that application. If there's a decision on your application and you are given, so if you apply for anything under point-based system, if there's a refusal, it will come with right to administrative review, which you have to put in within 14 days. So I think another thing you were saying, I will also talk about you kind of were talking about administrative review and judicial review. Those are two different things. But some people don't understand. You will say, oh, my lawyer did judicial review for me. But if you check the paper, it's the administrative review they did. You understand? So now, if you applied under any point-based system visa category, if they refuse it, it will come with a right to apply for administrative review within 14 days. If your application was under human rights, family life, or asylum, if they refuse it, it will come with a right of appeal. So you see the difference. Administrative review for point-based system visa categories, and right of appeal to the tribunal. That's the court. If it was family life, human right, or asylum, those are different category of visa applications. Now, for asylum or human right, family life, if your claim is unfounded, so like you say, okay, you have malaria, but you cannot go back to Nigeria because of malaria, and blah blah blah, they will just refuse it and say it's unfounded. It's certified as unfounded, and you'll be given immigration bail instantly. So there will be no right of appeal. But if your claim is a good claim, but they still say, oh, you don't meet one or two requirements. Let me use asylum, for example. If you claim that, oh, you are Bobrisky and LGBT is illegal, you cannot go back because you are at risk. That one is a convention ground to claim asylum. So that one, if they refuse it, because maybe they say, your story is not credible, you said this before, and now you're saying, so refuse it. If they refuse your asylum claim, they will give you right of appeal if your claim was based on a convention ground. So you have to appeal within 14 days to the tribunal. You understand? So even while your appeal or administrative review is pending, your Section 3C leave still carries on, meaning you can still work, you can still do anything that you were doing before your leave expired, as long as you put in an application before it expired. So now, a lot of employers, especially Oyibo employers, they don't know all these things because the HR is just a normal HR. They don't know anything about immigration. They don't have immigration lawyer that can advise them. Even some immigration lawyer don't know these things. So like that guy now, if his lawyer, maybe, I don't know if he has spoken to the lawyer. You understand? The lawyer would have said, okay, don't worry, I'll write to them, which is what I normally do for people. You understand? So what they will not, now for your right to work, you won't be able to generate a share code if you are put in application before your leave expires and your application is pending. Why? Because you don't have a visa anymore. Your visa has expired. But there was an interim application, meaning that what you now have is Section 3C leave. You understand? So, but you won't be able to generate share code because share code is showing right to work from 1st January 2025 to 1st January 2028. That one is right to work that will generate from share code. And that one is based on a visa. But if there's no visa, but you have 3C leave, you can't generate share code. So what happens is that the employer can only check your right to work via a platform called Employer Checking Service. So that is a home office platform that allows employers to check right to work of people that have pending applications. Not pending application, pending in-time application. So what they will do, you will give them. So like this guy kind of did the right thing. You send them they'll say, oh, your visa has expired, but have you put in an application? You say, oh yeah, I applied for British citizenship. Oh yeah, where is the application number? You give them. They will now go on that employer checking service online and check it. You can, I think you normally, you can check it. They'll now put your details, everything, and send it. Then that department, they will now check the system and say, okay, oh, this guy did application before his visa expired. Whether it's British citizenship you applied for or you applied to be prime minister, it doesn't matter. They will still say you put in an application. Then they will send back what they call a positive verification notice. positive verification notice. So it will confirm that you have right to work, subject to, that is this, the condition will be whatever visa you had. Like I said, dependent visa, full time, student visa, 20 hours, it will still be the same. So they'll confirm, and that positive verification notice is a statutory excuse to the employer to continue employing you for another 6 months. So that statutory excuse is valid for 6 months, meaning that that is your right to work for that employer only, valid for 6 months. So the employer doesn't need to worry again; they are covered. You understand? They don't need to check, do any other thing. They'll just put it on their record that, oh, we have checked right to work for Kunle, and Home Office say Kunle can work. And they have covered us for 6 months. So now, while Kunle's application is pending, you know, concern employer anymore because they don't do their own check. So now, if Kunle application now, they refuse Kunle application within 2 months, Kunle still has to put in whatever he can put, that's either administrative review or appeal, to continue benefiting from 3C leave. It doesn't mean that Kunle has visa. So there's a lady on one of your lives that said that the lawyer put fee waiver for her and they've given her till 6 months. That is not a visa. So she feels that she now has visa. No. It's just a statutory excuse for the employer. So there are some lawyers, sometimes maybe miscommunication, or that's why it's good to go to a lawyer that understands your background, because some of the Asian lawyers, sometimes you can't really understand it, or they don't understand your situation. They don't know, say, this guy will come, so Nigeria no go no going back. So you understand what I'm trying to say? They may not they may not be able to give you some kind of advice that will benefit you. You understand? So in some cases too, they may not explain it well to you. Or sometimes I've seen an employer giving someone, oh, we've done your right to work check, and it says it's 6 months. But they will not communicate it well, or they themselves don't understand it. So the person will now feel that they have given them visa for 6 months. No, it's not a visa. It's just a statutory excuse for the employer. You understand? And you have to follow up with your application if it is refused. You need to still put in administrative review or appeal if you are allowed to. You understand? So after 6 months, the employer will now do another one. So if you still have a pending application or a pending appeal or administrative review, if that application was refused, then it will the right to work will still come back again for another 6 months. You understand? And in some cases, even like asylum cases can take up to 2 years, including the appeal. So the employer will just be doing that right to work check every 6 months until maybe you switch, if you find a COS or they grant you, then everything goes back to normal. So for this guy, the employer, they don't know what they're doing, so they need to do the ECS check. And I've seen a lot of people that have been stopped from working because of the ignorance of employers like this. They'll say, you cannot generate share code. Oh, if you don't have share code, you have to stop you from working. But no, you don't need to. In fact, there's a guidance for right to work check for employers, which says that an employer cannot mandate how you prove your right to work. So they cannot insist that, oh, you must bring share code, because there are some people that at times you even have technical errors on your e-visa or your right to work. So you may not be able to generate share code. So there's a platform for employers to check right to work manually with the Home Office. And then another thing I must say is that it is only Home Office that can say who has right to work and who doesn't.
Who doesn't?
An employer cannot determine who has right to work and who doesn't have right to work. It is only Home Office. So, and that's why they have to contact Home Office via that employer checking service with your details, your date of birth, your application number, and all those things. The Home Office will now respond and say, oh, Kunle has right to work, or Kunle doesn't have right to work. Don't employ. Shikena, that's it. You understand? So, yeah. So I thought that's it. But do you want me to talk about the other things?
Yeah. Barr Eni, please.
Ask questions.
Yes, sincerely, you are the first immigration lawyer that will be coming here to talk to us. You know why? I'm sorry, in fact, you still have your flaw. You know why? I'm a diplomat. I'm not a barrister. Do you understand? But with what you have done today, honestly, I will soon join you guys here in the UK. I'm serious. I'm serious. At least to fight for these people, because nobody is speaking for us. for our people. As in fact, because the number of DMs I get per day. Now, do you know that? Okay, for you to keep talking, would you believe that a lot of our Africans, particularly Nigerians, have told me, I still have the DMs here, many of them, that they paid some of your colleagues here. They got the money, they collected the money, the fee from them, and they didn't do the job. They absconded. Just say something about that before people begin to ask you questions, sir. Please, if you don't mind.
Oh, well, I think, sometimes people are desperate, so they may not be dealing with actual lawyers. You understand? And yeah, let me just talk on both sides. Sometimes people are maybe they're dealing with agents, or there are people, even like, you do video on immigration. So some people who are desperate or out of maybe ignorance or desperation, if you want to now, if you are not a good man now, you can even, because people will start coming to you. If you are not a good man.
Lots.
So there are people who maybe have a very little knowledge of immigration. They pose as immigration lawyer and then they use it to exploit people. They collect money from them and they don't know what to do. They don't know. Maybe they can do fee waiver.
Yeah.
Fee waiver is a very simple application.
Somebody just said, I'm sorry, Barrister. Somebody just said plenty of them also. Plenty. You understand?
So fee waiver is easy. Anybody can do it. So maybe someone who has done it before and say, I can use this thing and be doing for people. Then before you know, they start help doing for people and collecting money. And when the thing enters, like this guy's the situation now, they don't know.
Yeah.
They run away. You can't reach them again. So, but regulated lawyers also are always they are regulated. Like myself, I'm regulated by SRA and I'm under AKK solicitors based in London and Bristol. So we are regulated, and everything is done in a very regulated manner. You understand? Even though sometimes I come online and do live and just help answer questions and all that. You understand? But another thing is for some clients too, especially our people, they call anyhow. Once they do something for them, before you know, they start calling for a very relevant thing. They can be calling you on Sunday morning, call you at 10 p.m. and
it's because many times, what you don't know, Barrister. What you don't know. They are panicking, they are scared, like you said in your word earlier, that place is a no-go area. You said it. So, and many times these guys are so scared because of what they've put into the society here and what they put into their coming over to save lives here in the UK. So it's not their fault many times. It's just that we have to give them, this, you understand, this partition, please do this, do that, and they will listen. But in a case,
so that's the thing. When you have clients, like we have a lot of clients, so some people maybe you have already explained something to them. They'll keep calling you to ask you the same question over and over again.
No, that's not.
Or home office can write to them and give 10 working days for something. They'll call you immediately, keep calling. It doesn't. Lawyers don't operate like that. So that's why you see some lawyers. Like me, I'm a bit flexible and accessible. So some people call me directly, but they sometimes abuse it because they will just be calling you just randomly. No courtesy, no appointment.
I know.
We both lawyer won't operate like that. It's like Kudus and the rest of them. You will not see. You don't even have their direct number. But a lot of my clients have my direct number.
I know Kudus. Now,
Kudus is appointment. You don't even have his. Once you book your email appointment, you talk on Zoom. After you don't talk finish, that's it. If you have something you forgot, I forgot to mention another £100 with that too. You wouldn't even see him. But me now, people will call and they call for the most irrelevant things. You understand?
Yeah, I know. Yeah, but can I just say this before you? Please, can I just say this before you take questions of people? I so much appreciate your selflessness and your humility of coming over here. Okay. This is your family. This is a platform, as you can see the name there, African Community Service. All we do here is for free, but your business is your business. However, there is still a way. I don't know. I'm being skeptical. Because I'm a very diplomatic and technocratic person. And I've been in the system for quite a number of years, and I've known the system. I don't want to be saying some things, ill things about our people here, but some of our people have not represented us well here, solicitors and blah blah. Now, I want to ask you this question for posterity's sake, because here I have got about 150 and 52. I'm not joking. I'm not kidding. 152. But I don't know as of now. Maybe other DMs, of course, must have entered after this live show. But as of now, 152 people who need legal, services and advice and all of that. I'm being skeptical, because of my name. Do you understand? Now the point is this: how available are you?
I'm available, subject to. So on live here, we can answer questions.
No.
For 1 hour.
You are going to do that. I'm talking about at your office, at your place, at your firm. Yeah.
Okay, yeah, I'm available, subject to an appointment, because immigration matter. You need to have time to talk to someone and explain things in detail. So being available is subject to appointment, a paid consultation.
Okay. Do you do
So
that
that
through Zoom? Do you do that
just
through Zoom or
I
Teams
do
or
it
what?
through Zoom, WhatsApp. Anyone is fine. Phone call, WhatsApp.
I'll still
Yeah,
find
anyone.
out. I'll still find out properly about you, sir. I'll find out properly
Okay.
do background check on you, and before I begin to say, because this is an African thing. Let's change the narrative that Africans don't help Africans. It's only about money, 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 money. What about people like us? And thank God for what you are doing now for free. Look at what you just did now. If they are to pay for what you just did now, I believe people will see that's the truth. But look at what you just did now. Anyways, please, if you don't mind, sir, take some questions. A lot of people are asking questions.
Can I
Are you
come
ready?
in briefly, just
Can I
to,
quickly chip in something
Please,
quickly?
let's do
it's
it
in
one at a
addition to
time.
what,
One at a
Please,
time.
Barrister is still talking, please. Please, don't worry. We'll allow you guys to talk. Let him
just in
Don't
just.
addition to
interrupt
what
me.
Barrister said, in addition to what he's saying, I want to
Who is that?
inform
Who is that? Who's your name, please?
Kemet.
Oh, Kenneth. All right.
Now, see, on the issue of that 3C leave, I wanted to say most of the things I want to say has been covered by him. But then, if before your application, you have an e-visa.
Yeah.
There was a case of June last year. It was a decision of court of June last year regarding this 3C leave issue. It was, of course, precisely taken up by as an agency, in a refugee and migrants forum, something like that. The court gave a decision on that 3C leave, and then the court decision led to a new development in
Wow.
3C leave issuance. Yeah. Now, the ECS was an analog sort of format for validating the right to work of those who have got 3C leave. Now, the new development now is that if you have an e-visa, as soon as you've put in an in-time application, the system automatically grants you right to work. You don't need the ECS. I'm just trying to update based on the information that Barrister Eni gave. Now, you don't need to go through ECS no more, which is why it's very important for you to have your e-visa before your visa expires. If you have your e-visa already active, you don't need to go through ECS. A lot of our people are ignorant. They don't read.
You don't read.
They depend on skit makers, which is very wrong. Content creators.
Eh?
The 3C leave can only be applied if you're going on human rights application.
Yeah.
If you don't have any intention of going on a human rights application,
Yeah.
you don't have any business with 3C leave. You will endanger and foreclose your chances of a subsequent application. There are other routes you can follow. Now, if you eventually get into a 3C leave and you have an e-visa, subsisting e-visa, you don't need to bother about ECS. The second you submit your application, it gets you activated. It gets your right to work activated. You log in, you access your share code. You don't have any problems with that. Just to add to what, and then the other person that was talking about sickness visa or something. Now, there's a bit of problem there. if you are claiming, because this is logical, beyond the laws, if you are claiming that there is a sickness for which traveling to Nigeria or outside Nigeria is going to put you in danger. Now the problem is, don't you think if you get a COS tomorrow, don't you think Home Office is going to be worried? This sickness is unable to make you travel. How are you going to work with that sickness? Because you have to be fit for the job. If you are not fit to travel, how then are you fit to work? Is that not contradictory? So, but I know there are some sicknesses. For instance, if you have certain sicknesses, you can still work with it. But on the basis of the fact that treatment cannot be effective outside outside the UK, you may not be able to go obtain treatment elsewhere. But there are certain sickness depending on your circumstance. Everything still boils down to your circumstance. If you are claiming that 2 legs are amputated, how can you be getting a care worker visa? I understand. So those are the circumstances you need to consider before you go into the route of claiming getting to a visa that going through the route of a health visa, a health difficulty visa. Thank you.
Thank you very much, my brother. I can see a lot of people. I can see a lot of people trying to authenticate Barrister Eni here. Honestly, this is my first time of coming across you, but I'm still going to, carry out my, my background check is. So over to you,
Yes,
sir.
he does amazingly well. He gives advices, and we know him very well. He's good.
Oh wow, that's good. My goodness.
Thank you very much for bringing me up this morning again. I'm just coming back from work, so I stumbled on the life again. I was like, wow, this is good. So once again, I appreciate. So once again, I want to appreciate Barrister Eni
Yeah.
Oja. Please, can I quickly buttress what he said the other time when he was saying that people doesn't understand their background and their situation sometimes. Now, I will just say a brief story, and I think to the glory of God, I've been in this country for 5 years now, to the glory of God. And when I came in, I was able to go through some background, stuffs about UK immigration and how it works. Now, when I came in as a student in 2020, I have this idea that I'm not going to get married to white. Neither do I want to do anything dirty because I want to have my paper. Because when I was coming, my uncle was telling my dad that I shouldn't have a girlfriend, that I'm going to get married here in the UK so that I will be able to have my paper. But within me, trust me, before I left my country, I said, instead of me to do that, I would rather go back to Nigeria and use my master's certificate to get job. I'm telling you, sir. So to the glory of God, I'm a prayerful person, trust me. So when I came here and I was praying, God, just give me the direction. But sir, immediately I stepped into this country, I started reading everything about the UK immigration system. I started reading everything about UK immigration system outside the idea of people getting married to the British before you have a paper. Do you get it? But that was when I knew that it is only when you are being sponsored, right, before you could, outside all of those things. And that was when I started putting up for NHS application. After over hundreds of applications, then I finally got a job. Now, when I got NHS job far back in 2021, and since then I've been sponsored by NHS. Now, this is it. Because of my comprehensive information and knowledge about UK immigration system doesn't give me the permission to be an immigration lawyer.
Thank you. Thank you. Thank
Do
you.
you get it now?
Yeah.
Because I have, sir, to be honest, I have comprehensive information. In fact, sir, I downloaded almost all the companies that sponsors in this country, schools and everything, to let you know the level at which I have gone to make my research. Do you get it? Now, yeah, fine. I am an agent. In fact, I am a British accredited consultant when it comes to education agent and all of those things. But in fact, till date, I never get involved in any COS selling. Do you know the reason? Because I knew the rate at which our people were going, then this thing it will cause issue. I never get involved in any COS. In fact, I got a deal from one agent that Mr. Prince, your company is this, your company is that. Please, can you please? I said I don't do it because I don't want wahala. Our people are so desperate when it comes to all of these things. So when people were coming to me, Prince, I heard you have people to come to the UK. I said, come. I'm not an immigration agent. I'm not an immigration lawyer. There's a limit to what I can explain to you. Fine. I have the understanding of how all this thing works. But trust me, I cannot give you, even me, I still need a lawyer to explain some things to me, to my understanding. Till date. If not, in fact, Mr. Eni Oja understands everything. In fact, you need to, as an African person, sir, before you can deal with my problem, you need to understand my background. So if you want anybody as a Nigerian, if you want anybody to understand your issue, most importantly when it comes to immigration, or probably you have been given some 30 days or 60. Okay, I have a family of 7 who reached out to me some couple of weeks ago. This woman, she just graduated and she doesn't want to switch on to postgraduate visa. She says her visa is going to expire by October, that she has got my number. In fact, she said two different persons gave me, that they don't know themselves, but they gave me my number. I said, okay, what happened? She said she had till October. I said, sir, ma, there's nothing I can do. Me, I don't know how to deceive. There is absolutely nothing I can do because I am not an immigration lawyer. If I am an immigration lawyer, an immigration lawyer can explain to you, okay, if you have what you can do, just like what the 2 baristas were saying here, they will give you alternatives. But I said, the man was like, no. I said no. It's not all about money. I get him in. It is all about the information you have at hand and how grounded I am in the system.
But Prince Will, do you know that our biggest problem right now is that a lot of persons out there have, simulated to be lawyers and they collected money.
That is where the issue. That is what I'm saying, sir. That
from this innocent
the fact that I have this understanding, I'm not a lawyer. I'm telling you. So people tend to take the advantage of the
people's downtime, people's problem.
Exactly. So I've seen this woman was telling me that somebody collected £1,500 from her just to make sure that, I'm telling you, to help her look for NHS job that is not there anymore.
Oh my God.
NHS job, I'm telling you, sir. In those days, I know my friends that when I tell you do this, trust me, in less than 4 months you get NHS job and COS. But trust me, all those things doesn't work out anymore right now. Are you getting me? So I told them £1,500 for what? And this guy collected £1,500. He called himself an agent. So these people tend to take advantage of the vulnerability of our people, to siphon funds and everything. So being an agent doesn't mean you are an immigration lawyer. So there's a clear difference. And look at how Mr. Eni was explaining. In fact, without you saying anything, you know that this man is grounded. Professional. He's well grounded. Sir, dude, I've wanted to use a lawyer since last year for some stuffs that I've actually started myself, but it got to an end. I told my wife, at this point, we need a lawyer. Don't say because your husband is smart, your husband is this. Smart no dey there and lawyers I told at this time we need a lawyer. But do you know my challenge? I will need a lawyer that understand my background, where I'm coming from, and my situation. I hate it when I'm speaking to these Oyibo people and they will be speaking English to me. I will be telling them what my problem. They won't understand. So at some point I was like, but should get a Nigerian British immigration lawyer. And trust me, this is the first time I'll be coming across a Nigerian British immigration lawyer. Are you getting that? Because at some point you need people that will. At some point you will leave Oyibo, and you come to Pidgin Gong so that people will understand what you are trying to explain to them. Yes, you will leave Oyibo alone because there are some people you will meet some Igbo people now. The way they speak, there's no how you can. They will try to speak in British. You won't understand them. And these people are in their serious situation. I have them in my corner. I told them, I'm sorry, there's nothing I can do. I'm an agent doesn't mean that I'm a lawyer. I'm telling you, I want share to me in Bashe, come up with me, just like what Mr. Eni said, sir. If these people started calling you, sir, you feel as if you are like all of your polluted. I'm telling you, if these people started calling you,
No, are you telling me with this kind of projects?
do you honestly? So
Come and see.
and I appreciate your platform too. Just like
Come and
what
see my DM. Come and see
another
my.
person say something the other time. Another
Yeah.
thing that is killing us, sir. Another thing that is killing us, content creators. Sir, content creators is killing us. Content creators, you see them, kiniko. This all of these new policies now. All of these new policies.
Just
I'm, I'm,
give.
I'm still looking for a lawyer to break down all of these point based. I'm still looking for a lawyer to sit me down to explain everything to me, because at some point, no matter how smart or how intelligent you are, you still need somebody who still has understand the nitty-gritty of how everything works.
Yeah, Prince will let's hear from that.
So please, our people just need to they need to
I
calm down,
understand
and
you.
they need to calm down and
Yeah.
watch people that they are dealing with. Trust me.
Yeah, thank you
And
very much once again.
by you feel like thank you.
Yeah, a lot of people here want to ask any question, but please, I need you to just go straight to your point. Don't let us delay me. Don't delay this learned man. Please let us try to respect the space we have given us, because everything we are doing here, including Barrister Eni right now, is for free for this place. Please let us try to respect that. If we give you the space to speak, just go straight to your point, ask Barrister your own peculiar challenge and let him answer. Barrister, please, you have the floor again.
Hello.
Yeah, you have the
Oh,
floor.
okay.
If a lot of questions are flying around, somebody has asked, okay, or let me ask about this. This ILR thing, for people that have been in the UK already, we have heard by the white paper. No, I mean, none of them will be affected by the new rules. But what happens about the ILR they are discussing and debating on September 8th, next month? About the 10 years, 5 years, 10 years. What can you say about that?
Well, the qualifying period for ILR is still 5 years, so nothing has changed yet. Even if they were to increase it to 10 years, it will not affect those who are already on the skilled worker route already. You understand? Because laws do not operate retrospectively; they operate prospectively.
Yeah.
So if you're already on a skilled worker route, you've been granted 5 years you've been granted leave under the skilled worker route, and the current rule says once you do 5 years, you can apply for ILR. You understand? So if they increase it tomorrow, it will start from the date it is being. It will start from the day it takes effect. Then, if you are switching from student route or graduate visa or whatever route into the skilled worker route, then your qualifying period would be 10 years from that date it takes effect.
All right. Yeah, please.
Yeah.
Can you still take some questions from our African community people here? They still want to ask you some questions. What about those on PSW? Is it still 5 years?
Yeah, just like I just explained.
Yes, now.
The
Yeah.
rule is still 5 years. Okay, let me give you an example. So, remember the March 11, 2024, when they banned dependents on for skilled workers, for care workers, right? So, if your COS was issued before that time, you can sponsor dependents, right? So, but from March 11, 2024, if your COS is issued on that day or after that day, then you're not allowed to sponsor dependents. That's how the law works. So in the future, let's assume 1st December, they say, ILR under skilled worker route is now 10 years from 1st December 2025. Then if anybody is switching to the skilled worker route from that date, then they'll be granted the visa on a 10-year route to settlement. That's how it works.
All right.
Let's not confuse people now.
Anyone wants to
law is
come
still
up and
5
ask Barrister any question? Yeah.
Barrister, can I ask some questions?
Yeah, sure, go on.
Okay, so I learned there are two different COS. I learned there are COS for family and there are COS for is that true? That's number one.
No, there's nothing like that.
Because
So the
I
problem
keep
is
telling
that
people that how would this two COS be two? One for family and one for no COS should be COS. So what
no, let me explain. I think I know what a lot of people don't understand immigration, even employers. So you see an employer issuing COS, and we say, this one will not carry dependent, it's not also dependent. So that one is not the employer's business.
that's what they
Employer
say.
cannot determine a visa application. They only issue you COS. If you have a family and you have children, then you come to the lawyer or you apply by yourself. Home office will be the one to decide, not the employer. So there's a place on the COS that will say certified maintenance for so then in bracket they will put dependent if it applies. So there are people that will now look at that place and say, oh, they put no, that it doesn't carry dependent, or they put yes, it doesn't. That's not what it means. So maintenance is just if they certify it and put yes, then it means you don't have to do proof of funds. You don't have to show proof of funds for you to apply. If it's no, then you have to, if you have not lived in the UK for up to 12 months at the date of application. Yeah. So those are little things that people just confuse themselves about.
And I
Even
think the COS stuff is explanatory enough. I think I've explained to about 2 to 3 people when they send their COS to me that this maintenance doesn't mean that and this and this and that. But our people tends to be honest.
that's it.
Sometimes people are a bit difficult where you are. I've scheduled some kind of consultation via Zoom with some people and try to explain some things to them, but they will feel as if you don't want to do some things or
They will say you are Batele.
Exactly. Thank you, sir. And
If you advise someone say, no, this application it will not work, they will say no.
they will know
This lawyer now,
exactly. But they will
not be their pastor.
collect.
Let me even tell you what shocked me. There was a client, I think I helped them with some kind of, I think FLR 6 months ago. So they have not gotten COS. So I said, they came and said, we've gotten COS. I said, okay, send me the COS. Do you know, this guy started asking me, why do I want him to send this? I said, send this. Let me see the COS and see if maybe the salary is not correct or there's anything there that's, but the guy refused to send the COS. So in his mind now, maybe he's, people are superstitious. Maybe if you send me the COS now, I will put bad belly on it.
Probably they will feel you want to copy the employer.
I don't even understand. Your own lawyer, I send COS. He refuse. So, my brother, I think you've really really know our people from the things they're saying.
Please, I have to come in now, please, Barrister. Please, is this your voice? Because I've been using just 2 of you. I want to confirm. Is this your voice, please?
Yeah, thank you for asking. I'll try and explain it in very simple terms and as quick as possible. So basically, from 22nd July. Yeah, that's my video.
Is this your video? Oh.
Yes.
Would you believe I'll be making use of this video because I studied this video, and one other video by an Indian man, and I've been regarding to you guys as senior immigration lawyers. So everybody, goodness I am I lying? For the past 2 months.
No, you're not.
Honestly, that we've been talking, and I've taken my time I just stumbled, somebody sent it to me for, we started this package about 2 months ago, but this one, I think about 4 weeks ago, or 5 weeks ago, I got this, and I've been using it here. Seriously. People here can bear with it. What? As we're just talking, and I'm trying to relate the voice with this. Now I can see your face. Okay. No worries. Now I get. I didn't know. I'm serious. I didn't know. Is it coincidence? Thank you very much, Barrister, for what you do for us. In fact, you explained it very well here and the other Indian man. So those two have been, of course, I usually play it every time whenever anybody asks any question regarding the new rule. How you have broken it down here, you have explicitly has really made the day of, everybody worthwhile. So thank you very, very much. So I don't know how to appreciate you for calling me. So in fact, it's like we still have some people asking. Prince Will, are you done with your questions?
We want
Yeah, Chris is
people
gone.
that would ask questions and not just come and fill in the
Yeah,
box. People have
I want
different
to.
questions, please.
I have a
Okay.
question, Uncle J. I want
Please,
to.
let's take it one at a time. Goodness and mercy, please control the question.
Yes, I want to greet everyone for this opportunity. I want to thank Barrister Eni for a couple of times. I've the opportunity to stay at the comment section to listen to him as he explained step by step way of getting your stay regularized. At a very large extent, I think I concur with majority of the things he say. I usually see him in there one guy again, lawyer, city somebody, say Yoruba guy that usually they collaborate together to help.
What's your name, please? What's your name, bro?
Myself?
Yeah, on TikTok. I'm trying to.
Respected ID Noble.
All right, go ahead, please.
Yeah. My question is just a brief one. And I have a brother. Yeah, he came with a skilled worker visa with the family. So the wife was the applicant. So the guy and the children are dependent. So he happened to have a problem in the workplace, and the case is in court. When their visa expired this August, before it expired, they have put the application in June. The May applicant now who comes out because of the pending case that is yet to be determined by November or so. They have not released the EU visa and that of the children, which are the dependents. They stated that because the father situation, that's why they have not released the father's visa and the children's decision from home office. Though the dependent, which is the father, is still working. They just give it 6 months, like the way he explained it just now. It's 6 months first. When you need share code, they now give first 6 months, which can be checked again by January or so. But they have not released that of the dependent, which is the children, and the other of the man. Though they have given leave to still work for the next 6 months. That's my question. Thank you very much.
Thank you very much. But over to you, Barry.
Sorry, I didn't get the question. What's the question?
Sorry.
I've gotten the story, but what's the question?
Yeah, the question now is why are they delaying the visa of the children? Since the children, does the determination of the court affect that of the children? I don't know if it calls student visa.
What kind of case is it? Is it a criminal case?
Yeah, it's a case of assault.
Okay, so what happens is that when you have, if you are an immigrant and you are under maybe a point-based system visa category. So point-based system visa categories are they include skilled worker visa, student visa, dependent visa, global talent. Those are point-based system visa categories. So if you are on any of those categories and you make an application for leave to remain or to extend your leave, what will happen is that they will check if you have any pending police case or investigation or conviction warning. So if there's a pending case, so normally once you are being tried or investigated or you are being prosecuted, the police will notify Home Office. You understand? So it will be on your record. So once you put in an application, your application will be pending till that case is concluded. You understand? So if the case is concluded and you are convicted or you are given a caution or warning, then your application may be refused under Part 9 or under the fact that you don't meet the good character requirement. So like assault now means you've committed a crime and you might show that your presence in the UK is not conducive for public good. Maybe you drove without insurance or you drove recklessly. All those small things can affect your visa under Part 9. You understand? So the application will be pending for as long as that investigation is pending. You understand? So for the children, even though it doesn't concern them, but where there is a family, there's a mother and a father and children, they will normally grant application for the children alone in the absence of one of the parents, because both parents have shared responsibility. You get, so the reason why the children are still pending with their fathers is because I believe there is a mother involved and they have shared responsibility towards the children. So everything will just be on hold till it comes. Even with the dependent zone, it will still be on hold because your dependent visa is dependent on the success of your main applicant's application. So everything will be pending.
Like I said, the male applicant who is successful is just the spouse and the children.
Okay, the spouse. Okay, the spouse is the one. The dependent is the one that has the police case, Abi.
Yes, yes, yes.
So it will be pending now. It will be pending. The main applicant has the right to get their visa. You understand? Since they don't have any case, but the dependent one will be pending till that case is resolved.
Okay, thank you so much.
All right, you're welcome.
Yeah, the next person. Come to Joe.
Good afternoon, sir. Good afternoon, sir. Barrister, good afternoon, sir. Thank you for the work you are doing. God bless you. I have a question. I have an encounter with one employer. I think that should be 2 weeks ago. Though I was trying to get a place for my second for 20 hours. I'm on COS. So I've passed through all the interview stage and everything. And what left is just for me going through their training material. So I was asked to send my COS letter. I don't know if that one, if it's okay for me to do that. Though I sent the COS to them. So after checking, I now received a message that the COS is not under care, so they can't grant my 20 hours to work with them. I was surprised. Skill worker visa, can it has any restriction for a particular job, or I was somehow since he said it's not in care, so they can't give me that. I was just like, what is a skill worker? I'm entitled to 20 hours to work with an employer which employment or the job is under the skill worker list. So why this person asking me or telling me that my visa does not state I'm not working yet, so I can't get they can't offer me the job. So I was like,
Yeah.
what is
Okay.
going on?
So there are two things involved. Either the employer is totally ignorant of the rules or the guidance about your right to work, or they are relying on the old guidance. So previously, I think that was last year. I think January last year it was changed. You could only do your 20 hours within the same occupation. You understand? So if you were a care worker, you could only do 20 hours within care. So let's say you are a care worker, support worker with NHS, you can do your 20 hours as a carer in a care home. You can't do it outside care. But that rule changed last year. Now you're allowed to do your 20 hours in any occupation that is eligible for a skilled worker visa. You understand? So 20 full time as a carer in a care home, you can do your 20 hours as an IT, data analyst, chef, anything, as long as that job, you actually know the rules, but the employer doesn't know it. So if you
I
can
was
write to them,
I didn't even bother to write because I just look. I say this one doesn't even know anything.
yes,
So I was just
they
laughing
don't
over
know.
it. Honestly, even the job, when I look at the distance, I say it's just too far. Bullshit to them. I say it was kind of ignorant. Even the HRO doesn't know what he's doing. Even the crew, people that work alongside with this HR should be able to know the rules. That since I'm on ski worker visa, I am entitled to 20 hours to work in any this in ski that's under the shortage. In why this one deny me? I don't want to bother and waste my time. I just have to ignore.
Yeah, thank you, my brother.
Okay.
Barrister have answered your question. Let's go to the next person.
Good morning,
Ade.
sir. Good afternoon, sir.
Yeah, yeah, you're welcome, bro.
Okay. Good afternoon. Yeah, please, I just have a work question, please. My COS license was revoked this year, but my visa the state run it till next year March. Then we lost the company. The company have been liquidated. I applied for 20 hours in another company. I did it, I did everything, and I was taken. After working for 1 month, they wrote to me that they can't give me shift until I get a new sponsorship. But I told them, my right to work is working. Is everything is still working? The visa is still working. They said, no, I have to get a letter from home office to say that, yes, I am still allowed to work.
Okay, well, the company is partially correct, but they don't really understand how the rule operates. So what happens is that your visa conditions says that you have to do full time with your sponsor, 20 hours supplementary employment with another employer, but your 20 hours is subject to you working full time with your sponsor. Do you understand? So someone who's maybe your company, they've lost their license, they don't have shit for you anymore. That means you're not working with them, Abi.
Yes.
So according to the rules, you are not allowed to do the 20 hours because Home Office discovered that people were coming in with COS with the company, but that company doesn't have work, so they will not be doing 20 hours here and there. So it defeats the purpose of the skilled worker visa. It's not for people to use it to come into the country and come and be doing 20 hours. No. So the rule is that before you can do 20 hours, you must be working full time with your sponsor. So that's why some employers, the ones that know, before they take you on 20 hours, if you're on a skilled worker visa, they'll tell you to bring, sometimes they can say you should bring pay slips from your sponsor. They want to see that you're working for them and they're paying you. Sometimes they might ask for reference. So some people that their company is nowhere to be found, they won't even be able to provide reference. Then sometimes they will ask for the COS to see who your sponsor is. Then they will go and check online to see if the sponsor still has a valid license, just to check that you're working with them. You understand? So in this case, they are actually correct, but Home Office cannot give you any letter to say you can work. You have right to work, but you don't meet the condition to do the 20 hours. You understand? So what they can do, what I normally do for people in this situation, because there are a lot of people in this situation, what I would do for you is I'll write to them and advise that, okay, if they have the license, they can sponsor you outrightly to become their permanent staff under their sponsorship. But in terms of the 20 hours, legally, they are not allowed to give you that 20 hours because you are not working full time with your sponsor. So, like I said, another thing is people have to understand the idea behind rules and policy changes. So, the idea is that ABC Limited will not go and collect license, bring Kunle into the country, but they don't have work. Then Kunle will now come in as a skilled worker, but he's not working for the sponsor. But he was now doing 20 hours. Yeah, and so it defeats the purpose of that of the visa. That's why it is restricted. But you know, people that don't understand, they'll say, this company, they're wicked, they're racist, they don't want to give me 20 hours. No.
That's the truth. I was surprised. I said, I don't know. Maybe I don't know whether it's just punishment or something, but thank you.
No, they are correct. They are correct.
Bless you, sir.
Yeah, let's have you, Baba Parvez. Baba Parvez.
Hi. Hi, both. Right, yeah.
Yeah, please, my brother. Before you have a word with the barrister, yeah, I like to say this. That my guest that we brought the other time, Mr. Ben, asked me to apologize to you that he didn't send that message to you intentionally. He was actually going to write a different thing that you mistook. I mean, it was a mistaken identity that you now blocked on TikTok. He said I should apologize to you that he meant to write a different message. I think that was about 3 weeks ago. So Baba Parvez, don't be annoyed, okay, with what happened, okay? Feel sorry, please. Ask your question.
Yes, my question is, last time I also discussed with you my problem, like I am as a, here on postgraduate route, and my visa will be finished after 5 to 6 months. And I completed my degree from Lincoln University. It's related to Master of Arts in Education, like it's teaching field. But I am trying too much in this country to find the job regarding to like my field. But it's very, very difficult, and no any person will be the teaching field So that's why I'm very worried. So, I just request you, what is the other way? Because I don't want to go back, and I have just 5 to 6 months left, and I have no option. Yeah.
Over to you, Barrister, please. Did you get his question?
No, not really, but I think I understand. So it's about looking for job now. So I don't normally lawyers will not they don't provide jobs or cannot advise you on how to get a job. You understand? So
Uh,
yeah, and your question is something you need to seek a paid consultation to discuss your circumstances in full.
You know,
So what we're doing is making quick.
I repeat my question again. You know, my question is, if I want to apply for a sponsorship job in this country, like teaching field, teaching job. So, what is the best way? Because I try too much on Indeed and other websites, but no
I
any
think you're
company
asking for
respond.
career advice. So this one is we're talking about immigration. This one is career advice. I don't talk about jobs. It's talking about
Okay.
jobs.
Baba
Uh,
Pervez.
yeah.
Baba Pervez. What will you do? What you do for me is, What you do for me is, please, have you subscribed? Have you subscribed to this page?
Yes, yeah.
Have you subscribed?
Subscribe.
Yeah, try to subscribe. Then I will take you to our green app. Then you will meet with someone who will help you.
Okay, I will subscribe, and please tell me other question. You know, my another question.
Oh,
You
okay.
have, yeah, you have any idea about 6131 job here? 6131 code of this job, like it's nursing field job here. So I just need some theory about this job. Can you tell me that dependent is allowed on this field after 22 of July? Can we still stay on this? Like, if anyone give me the sponsorship, so please tell me now, after 22 of July, can I live with my dependent in this country or not? Just tell me.
Barrister, you can answer this one. This one has to do with immigration, yeah. Because it's got just 6 months.
If you have kids in the country, then most likely you might be granted. You have
22.
children. Yeah.
Oh, nice. Because you know, my wife is working on the one chair field. So the employers say, we want to give you the sponsorship after 3 months. But I am very like I am not fully sure if she get the sponsorship from that employer. So can I live in this country as a dependent of my wife or not? So that's usually.
You can, you can.
Huh?
You can.
You can. That's what the barrister is saying, yeah.
Okay, okay. Thank you so much. Thanks a lot.
You're welcome, Baba Pervez.
Thank-
So please there are things you can see here. There are things you can see because of TikTok. They've warned me twice not to strike, not to bring down this page. And it's working massively for Africans in diaspora, not only for people in the UK. So we can't afford to lose this page. So please try to subscribe. Then you send your mobile number to me. I will add you to our WhatsApp group then for free. Everything for free. Then we'll take it up from there. Okay, that's what we're doing. Okay, Baba Pervez. Now, the next person, please, Mr. Messi, who's the next person, please?
Good afternoon.
What's your name?
My name is K.
All right, yeah. You have the floor. Please make it snappy.
Okay.
Yeah, Barista is here.
Good afternoon. Please, I got a skilled worker visa last year. So it's a domiciliary care, and I didn't have my license. They stopped me because I wasn't driving. So, but on my Gov UK, I still have my right to work in 2027, and I no longer work for my employer. So if I to get a new COS now with the new law, will I have to work with them for 3 months before I can start with the new COS?
I know the answer to that, but let Barista answer. Barista, over to you.
No. So you're already on the route. So you don't have, the 3 months doesn't apply to people who are already on the care worker routes. Okay. Because technically, what visa will you use and work with them for 3 months before they sponsor you? You're not working with your sponsor, and since you're not working with your sponsor, you cannot do 20 hours with them. So there's technically no visa you can use to work with them. So that rule doesn't apply to you. They can issue you COS instantly, and if you apply the next day, your visa will be out within a few days. So that 3 months rule only applies to people are on other immigration routes like graduate visa, dependent visa, so it doesn't apply to you.
Yeah. So
Okay.
sorry, one more thing. What about the 20 hours? That means I'm not able to work with any other employer with the 20 hours since I'm not working.
Yes, if they follow the rules, an employer will not give you 20 hours.
Yeah, but I just said that. Yeah, you just said that. Not quite long. Yeah.
Thank you very much. That's all I need to know.
Oh, my brother, you're welcome. By 2 p.m.
Good afternoon, everyone. Barista, thank you so much for the good work you're doing. May God continue to bless you. And Mr. Ayo, thank you for being there always.
You're welcome,
Yesterday,
brother.
I came up to speak about my friend that I told you about yesterday.
Okay, I remember you. Yeah.
So I just need to ask a question so that I can give him some information because he's not a social media person and they rely so much on me. Let me say on God. But even me, I don't really know much about it as well. So that's why I'm always here. So my question is, I told you the wife came here to study. So the term she was working for, they gave her COS around January this year. So the COS code was 6135. So she applied with her husband. The salary threshold was 1175. Yeah. So when she applied, Home Office sent an email to her employer to inform them that the salary does not meet the threshold. That the salary is supposed to be 1190, not 1175. So maybe the employer was busy or something. She couldn't respond to the email immediately. Then they sent her another email that they would decide on the information they've got with them. So unfortunately for the lady, Home Office refused the visa based on the fact that the salary did not meet the threshold. So the lady went back to her employer to explain to them. Then they gave her a letter to back it up. Then the employer printed out the email they sent to her from the Home Office and her response. Because when the lady told her that they refused a visa, she sent an email to Home Office to question them that why did they refuse the visa? So they now forwarded that email to them again that they've told you that this salary cannot meet up with this COS. So she now responded that she tried to update the COS, but she was unable to do that. So she printed out that email for her to attach to the letter they gave to her to submit for her administrative review. So when she submitted, she has not had anything up to now. So they are so worried. That was why she was applying for biomedical science. Maybe she will get another COS. And that was when I spoke about the self-sponsorship yesterday. So I don't know, is there any tendency that they will get a positive response based on the letter given to them from her employer? So that's my question, please.
Okay, so let me explain. So what happens? So like the guy I told you about, my client who refused to send me COS because I thought I was going to Barcelona. So what happens that a lot of employers sometimes ignorantly issue COS with the wrong salary. Now, the salary requirement for 6135, 6136, even 6131, which is a NHS, that's what they normally issue. Salary requirement is £12.82 per hour. £12.82 per hour at 37.5 hours per week.
Yeah.
Now, some employers, what they will do is that, so that will make it 25,000 a year, minimum 25,000 a year. So some employers, what they'll do is that they will now go and say, okay, they're paying you £12.21. Then they'll put the hours at 40 hours a week, just to make it. Then when you calculate it per year, it will now be over 25,000. No, that is wrong. It still doesn't meet the salary requirement. So because the salary requirement is hourly rate, not even so you cannot increase the hour. You cannot pay less than the hourly rate, but increase the weekly hours to meet the salary requirement.
Yeah.
You understand? It has to be £12.82. You understand? So now even if they issue the COS, like I've had to tell some employers, oh, this COS is wrong, you put the wrong salary, they are going to refuse the application. So what they will do, they will now either issue a new COS or they will correct it. But even if they issue a COS with the wrong salary, Home Office will apply what they call evidential flexibility. They are going to contact the employer and say, oh, ABC Limited, you issued a COS, but the salary is so. The salary requirement is 12.82. Can you confirm if this is what you are going to pay or blah, blah, blah? So the employer now has the opportunity to correct it and say, oh, sorry, we can confirm that we're going to be paying him or her this so and so and so. You understand? So before a home office will refuse an application because of the salary requirement, they would have contacted the employer first. They won't just refuse it like that. In fact, Home Office does not just refuse application just like that because they want to punish you. They always give you the opportunity to provide a document or an information to help them make a decision. So if you look at Home Office, they're not wicked, they're not racist, they're not bad belly. So
Yeah, I like that.
evidential, yeah, it is what they call evidential flexibility, which means that they have to, if you've applied for something and you didn't provide a particular document that is they need to make a decision, they will write to you, give you 10 working days to provide that thing. It's when you don't provide that thing, they will now refuse it and say, oh, we on so day we wrote to you. The email was sent to, they will quote your email, but you did not respond, blah, blah, they will now refuse. So the employer maybe, and some employers sometimes they will, oh, they did not see any email from Home Office. I don't know. Sometimes they're lying. Sometimes they are honest. You understand? So in this your case, what they will do since they've refused it, I believe they put in AR. Abi, is it? Oh, the guy is gone. So I believe they put in AR. So any information you submit for the AR or any document you submit for AR
He
that you
said
did not
yes.
submit at the
He
time
said
of
yes.
application.
Barrister, he said yes.
Okay,
Yes.
okay. So the AR administrative review is likely not going to succeed because administrative review is for case working errors. So you are allowed to challenge a decision or a refusal by the Home Office by putting in or requesting for administrative review. So administrative review is basically saying they are going to review that decision and see whether the caseworker did not follow the immigration rules
Immigration
or did not
rules.
follow one law or one guidance. You understand? If they now see that, oh, this caseworker, the rule says A, but the caseworker refused and said B, then it will now change. They will withdraw the decision and send it back for reconsideration. You understand? That is how administrative review works. Now, for administrative review, you cannot provide new evidence. You can only provide any evidence that wasn't submitted when you did the application is not going to be considered on administrative review. So this letter that you're talking about that the employer sent, blah, blah, is not going to work because the decision was correct because they didn't meet the salary requirement under the immigration rules. So any letter afterwards will not work. You understand? Because they don't accept new evidence. The only time they accept new evidence in administrative review is when that evidence is to suggest that deception or false document was not provided in support of an application. Understand? So that one's another long explanation, but let me just focus on this guy's case. So the best option for you is for the employer to issue a new COS while your application, your AR is pending. You are still legal on 3C leave. So let them just issue you a new COS with the correct salary, and then your application will be granted. Very easy. So there's no need to wait for the AR. AR now takes more than 6 months. At some point, it will come back, they will maintain the decision, and then you will be on immigration bail.
Yeah, thank
Yes.
you very much, Barrister. But they gave three of them. They gave three of our colleagues the same COS, and they approved it for others.
Well, these things
It was
happen.
only
But
Abu that
sometimes
they
you don't
didn't
know
approve.
why. But was the salary the correct salary at the time?
You said what, please?
Because
Was the salary the correct salary at the time?
The same, yeah, that was January. The same salary, 1175. That was what they gave to all three of them, according
No,
to
no,
what
no.
she told me. And they are
So it's not about other people. So in immigration, you cannot apply for something based on another person's decision. Say, oh, they gave my colleague, so you must give me. No, it doesn't work like that. You understand? So even whether the salary was wrong or not, maybe the caseworker ignorantly approved their own too. But what we should focus on is, was the salary on the COS, was it the correct salary?
I don't know much about it then, but the salary was that was there was 11.75 per hour on 44 hours per week. That
No, I
was
don't think so. That was before April this year, B. So I don't think it was the correct salary.
that was before they made the announcement. They gave them the COS around 6th of January. That was when they gave them the COS. So they've
Well,
not made the
I don't
the
remember
new
what
law.
the salary
They've
was
not
at
changed
that
it.
time. I don't remember what the salary was at that time, but the
They've not
point is
increased the
that,
salary then. They've not decreased the threshold then. They've
so
not.
what was the salary? So it would have been the hours. The salary was the salary was wrong because, like I said, the hourly rate is based on 37.5 hours per week. So that
Okay.
£11 something would have been, I don't think it was the correct salary, but they don't increase the hours to make it meet the salary requirement. But it's not done like that. The salary is based on the hourly rate, not on the hours.
Somebody said it was 11:44, barrister. Yeah, at that time.
Okay, it was 11:44. Okay, the cases like this, we need to see documents. We need to see the client and ask the question. Because
Evidences. Yeah,
there are
that's it.
certain things you don't know. So we need to see the
Now, I
receipt.
saw the COS before they submitted the application. I saw the COS and it was 11.75. I saw it before they submitted because
So that means the decision was wrong now. That means the
it
decision
was
was wrong.
11.75.
Okay, so that means the decision was wrong. So if they have done AR, then the AR will succeed because as long as the hourly rate was correct, then the number of hours per week doesn't matter.
Okay.
But you cannot reduce the hourly rate and then increase the weekly hours to meet the salary requirement. So, like, I don't know what the salary. The salary this thing changes every time. So now it's £12.82. That's what I know, but I don't know what it was that time.
Now,
But if it was
that time,
11:44,
before they submitted, they've not increased it because I knew when they submitted. I was with them when they submitted it. Then they've not
okay.
made.
So let us see the decision. The decision will normally quote the rules and why it was refused. So let us see the decision, then we'll be able to discuss it. But if
The decision was that the salary does not meet threshold, that it was supposed to be 11.90, but they've not made the new law then.
So are you sure the salary requirement was 11.90 when they issued the COS, or it was 11.75?
I'm not sure because I don't know. I don't know the salary threshold. I don't know.
So I don't know what the salary requirement was at that
Me too,
time.
I
So
don't
this is
know
why
today.
we need to see the document. Yeah. We need to look at the rules at that time. You understand?
Okay.
Yeah, but so regardless of what has happened, let them issue a new COS so that she can apply and switch. Very easy. No need for long stories.
She's been speaking with them since January. She's been speaking with them since January, and they said they can only issue COS out till next year January. They can't issue any COS more this year again. That they have to wait till next year January. So that was the response they gave to her.
Okay, no problem.
So,
no problem.
But please, one last question, please. So, Barrister, if paraventura the administrative review was refused, is there anything they can do before, or they have to leave the country?
If they reject the administrative review, then that will be the end of their 3C leave. So they will be subject to immigration bill.
So they can't go. They can't do any appeal. They can't do anything again.
No. There's no. You can't appeal administrative review now.
Okay.
You can't appeal the decision on administrative review. You can only do a pre-action protocol letter challenging the decision, but only if the decision was wrong. So people that do administrative review, they are more senior case workers. They know, they have more knowledge. So it's very difficult for AR to come back negative or to come back wrong, because those ones are specialists. That's why AR is taking a long time, because they have few specialists but thousands of administrative review. Because some of these case workers, they don't really know much. They're just normal people that when they recruit them, they just train them for a few months. So sometimes they will be giving wrong decision. They don't know. They don't really understand. Yeah. So
All right. Thank
that's
you
it.
very much. Thank you. God bless you.
All right.
T-boy. T-boy. Jamo of London, please.
Hello.
All right,
Can you hear
T-boy.
me now?
Yeah, you have
Okay.
the
Yeah.
floor.
Good
Please,
afternoon.
please put your mouth closer to your mouthpiece.
Okay. Can you hear me now?
Yeah, it's better now.
Yeah. Quick one, because I'm at work. So, my wife was given another
Please
employment.
help us work on your background, please. No noise.
No. Here is so silent.
All right.
So the COS that brought us here was revoked, but fortunately for us, we got another job this year, March, and she has worked with them for 3 months, and they confirmed that, and they said they have submitted our application, but we've not heard anything now. She joined them in March, and this is August. But to my surprise, last month, she's only doing 20 hours with them. So after 20 hours, but they said she can extend her work, then they will pay it to my account, and which they are doing. But now I can see that last month's salary was paid to our account directly. Even this month was paid to our account directly. So, and we've not gotten another COS from them. So I'm like, what is happening? Is it that they've seen the green light from Home Office? They've not issued us COS, but they started paying us the correct hours. So I'm just so curious to know what is happening. Please,
Bro.
are we on a safer side?
Yeah, bro. I mean, is this the first time here?
No, I've been listening. This is not my first time.
Please, you have a barrister there, you have a diplomat here, and you have our administrators here. Try to send her to me at least one coin.
No problem about that. Sorry. sorry.
Gift a barrister, gift us, gift. I mean, thank you. Do that. It's important.
No problem. I do. Sorry.
Yeah, thank you. Barrister, over to you, please.
Okay, so you said what did they apply for? Is it COS or the skill worker visa itself?
She's on skilled worker visa, so they apply for us, but we've not heard anything.
No, now what did they apply for you people?
COS, another sponsorship.
Okay, so they have requested for COS for her.
Yes, for over 2 months now. We've not heard anything. They said she has to work with them for 3 months, which she has done that. She has finished. She joined March, then they confirmed that in June. This is July,
What
August.
visa did she have before? What was her previous visa? Is she the skilled worker?
Skilled worker, yes, 5 years.
Okay, so the 3 months doesn't apply to her now. Doesn't apply to her at all. Then for the COS request, there's a lot of there's massive delay in Home Office releasing COS to sponsors or employers. So you just have to wait.
Then I just want to know, maybe our wages is okay. They are paying £2.21. So
£1.21.
Yes, per hour. I said maybe that's the problem.
The salary requirement is £12.82. But even if they're paying her £12.21, as long as they put the salary, the correct salary on the COS, then that will be fine. So they will now have to start paying. Once her visa is released, then they will start paying her the correct salary. So minimum wage is £12.21. So anybody can employ you on £12.21. But for the purpose of a care worker visa, under that occupation code 6135, 6136, or 6131, the salary you have to pay to sponsor somebody is £12.82. So if you are employing me and I'm on a dependent visa, the law says you can pay me £12.21. But if you want to issue me COS for me to apply for skill worker visa, then you have to now start paying me £12.82.
So in this case now, what do you have advised us to do? Should we need to call or we should wait for them to come out with their own?
There's nothing to do. Just wait for the COS to be issued. Then they will assign it to her and then you apply.
Okay. Thank you so much. Thank you
All
so
right.
much. I really appreciate
You're welcome.
We are closing by 2, please. Our chief moderator is in the
Yeah,
room.
2 o'clock.
Yeah. Did the girl?
it. You say?
Yeah, not you, please. Goodness and mercy. Who's the next person, please? Let's not keep Barista waiting.
Hello, it's Jamo of London. Hello.
Go, Jam of London, please. You have the barista in the house.
Hello, good afternoon, Mr. Ayo. Good afternoon, Mr. Eni.
You're welcome, my brother. You've not sent gifts to the to Barista Eni, please. You've not sent gifts
Yeah,
to
sure, I
me.
will. Yeah, I will. Firstly, I have two questions. I have two questions. One has been answered already because I have Mr. Eni number. So he has
Wow, that's good. Yeah.
me. So last month, so I understand UK very well. And secondly, to my because I'm a displaced worker as well. Because most of us, number one, as a Nigerian, because we are a family here, as Mr. Ayo used to say. Most of us does not need to research. They will be following social media, content creator, and they will be putting themselves in a you understand what I mean, Mr. Ayo? So then I want to talk about the space worker as well because I have an experience since I came to UK. My visa was revoked. So if anybody wants to go and work at the 20 hours, most of them, if they hear that your visa is revoked, you will not be issued that 20 hours. Notice because it has happened to me. No, it's not once, it's not twice, it's not thrice. Because I have been listening to so many people this week saying that if they tell the company they are working doing 20 hours week that we about sponsorship, they will not like you have been revoked, so you are not allowed to do 20 hours. So we should be guided by that. That's what I noticed. That's the information I want to pass. That's all. Thank you very much.
Oh, my brother, Jam of London. Yeah, goodness and mercy. Over to you. Next. Yeah. Oh, Olori Kenny, are you there?
I don't think she's there.
I'm here. I'm here. Good afternoon, sir.
You're welcome, madam. Happy Sunday to you.
Thank you so much. Good afternoon, Barista. Thank you so much. Thank you so much. Quick one, please. I want to ask. Last week, somebody got banned on a visa application for 10 years. So, and we don't know how to go about it. Is there anything we can do?
Please say that again. Somebody
Got banned from UK last week.
Okay.
On a visa, yes, visiting visa. She applied for visiting visa and she was banned due to, I think her agent used a falsified documents and she got banned. So we don't know how to go about it, sir.
Well, it's unfortunate that people are still using all these agents to do application. They are still forging documents. At this, things like this were done maybe 20 years ago, and people were able to get away with it. But nowadays, Home Office checks everything. Anything you submit, they will go and check it. They have people everywhere in the world, anything from every country. Even divorce, better. Even what we do in my firm, when we want to do entry clearance application, we have to verify every document, marriage certificate, birth certificate, before we submit it. You understand? So in this case, the only way you can challenge that ban is if you can provide evidence to show that that document wasn't false, or it wasn't falsified, or it wasn't altered. That's the only way out. If you can't do that, then that ban will remain there for 10 years. The only other way out is if she's going to come in as on a spouse visa to someone who is British or present and settled in the UK. So that means she's coming through family routes. That's the only other way she can come into the country.
Okay, thank
Apart
you
from
so
that,
much.
all right. You're welcome.
Yeah, goodness and mercy. Next.
T-boy. T-boy.
T-boy.
I have spoken now. He spoke
Ah.
before Olori.
Okay, yeah.
He spoke before Olori.
Please, the next person. we got one more person up. I think that is Sylvester.
Let's bring this woman up, Jovita. I can't bring her up. Jovita, she has been asking this question for a very long time now. Maybe you should bring her up.
Jovita, okay.
Yes, I can see her name, Jovita.
Can I come up, please?
Yeah, you are up already. Just ask your question, sir.
All right. Oh, thank you so much. I just want to ask Barrister. I've been in this country for 6 years. I seek asylum. Then I was refused. Then I was given an opportunity to appeal. I do my appeal. Then on the appeal, then unfortunately my wife in Africa came back with my children. But she came as a couple married to another person. Then on the process, we are able to reunite and have a baby. Why she never submitted divorce with her previous husband. Then now we apply for the baby for his own status. They refuse the baby based on my status. Is there any chance they give us 14 days to do administration review? Is there any possible chance for me to succeed after the review is made?
Your case is very complex, so it's not something we can answer on live. We need to see documents. We need to see a lot of things to be able to advise. So you need to book a paid consultation and then provide documents. All these things you're explaining, we'll provide the documents and then be able to advise on that.
All right, sir. So I've taken your email address, huh?
Yeah, the WhatsApp number is on my bio, so it's
all right.
Only for paid consultation.
All right, no problem. I'll WhatsApp you.
Yeah. All right.
Yeah. Jovita, are you there?
She's not up yet. You didn't bring her up.
I've been picking her. I've been accepting.
Yeah, she said she sent requests severally.
Jovita.
When you are up, please mute yourself. Don't come up with this noise.
Oh my God.
Can you make me a moderator here? Let me.
You mean the girl? Are you not moderator?
I'm not moderator with this my account.
Oh.
Yeah, that's why I've been asking you to do this. I won't ask you to do it.
So sorry, Barrister. Please. Why even know this thing again? Why is your face not? Did you get? I can't see.
Yeah, if you cannot see, just leave it. I'm just saying that we need to bring Jovita up.
Thank you, I'm up.
Yeah, I've been picking her. All right.
Okay, she's up now. All right.
I'm even trying to bring Did girl. Okay.
Jovita, can you please go ahead and ask your question?
Please, my question is this code 6131 for nurse assistant. If they issue it after this July 22nd, maybe at the end of this August or September, can it cover dependent? Because just me and my husband alone. All our kids are adults. So and we've been here since 2023. So
Are your kids in the UK?
The eldest just came for his masters in January. So because they are all adults, they couldn't come with us. It's just me and my husband. So I don't know, because my company, they are willing to give me sponsorship at the end of this month. So I don't know if it will cover my husband with this their new rule.
Okay, so the dependent ban only applied to 6135, 6136, which is I think home carers and senior care workers. So for 6131, auxiliary nursing